School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 2 Business Forms and Legislations. Unit 4 The Companies Act 2013 Part 1.
After completing this unit, you should be able to understand the meaning of a company form of business, define a company and describe its characteristics and types, explain the stages in formation of a company, explain the meaning and importance of promoters, identify the need for memorandum of association and articles of association, explain the meaning, importance and contents of prospectus, explain the meaning of shares, share capital, debenture and deposits, understand how a company is managed and the role of board of directors, and explain the meaning and mode of winding up of company. Introduction. The expansion in business needed an unlimited extent of capital. But the unlimited liability of the partners of the traditional partnerships under the Partnership Act 1930 became a hurdle to meet the capital requirement. The corporate form of business helped to solve this problem through introduction of concept of limited liability. From formation to its winding up, a company is governed by Companies Act. Apart from the Companies Act, the Parliament of India has enacted several other acts like the Company Secretaries Act, the Competition Act, Monopolies and Restrictive Trade Practices Act, Indian Partnership Act, Sikh Industries Act, etc. to have a control over the changing corporate world. The Companies Act 1956, which preceded the Companies Act 2013, had numerous amendments, making it a complicated legislation with overlapping provisions. As it was becoming increasingly difficult to implement the Companies Act 1956, the need to streamline the legislation and reduce regulation was recognized. As a result, the Companies Act 2013 was enacted, which consolidates and amends the law relating to the companies. The Companies Act 2013 is divided into 29 chapters containing 470 sections and 7 schedules. A sizable part of this act is in the form of Companies Rules. Applicability of the Companies Act 2013. The provisions of the Act apply to: Number 1. Companies incorporated under this Act or under any previous company law. Number 2. Insurance companies. Number 3. Banking companies. Number 4. Companies engaged in the generation or supply of electricity. Number 5. Any other company governed by any special act for the time being in force. And number 6. Such body corporates which are incorporated by any act for time being in force, and as the central government may by notification specify in this behalf. In each of the case, that is, from point 2 to point 6, the provisions of the Act should not be in conflict with the provisions of other Act, that is, Insurance Act, Banking Regulation Act, Electricity Act, etc., by which the company is regulated. And if it is so, the provisions of respective Act or Acts to which it is governed and regulated by shall apply. Formation of a company. Company means a company incorporated under this Act or under any previous company law as per Section 2, Clause 20 of the Companies Act 2013. This definition does not clearly bring out the meaning of the company. To define and understand the nature of a company, the outside attempts and judicial decisions may be explored. Accordingly, a corporation is an artificial being invisible, intangible, existing only in contemplation of law. Being a mere creation of law, it possesses only those properties which the charter of its creation confers upon it, either expressly or as accidental to its very existence. This definition is as per Chief Justice Marshall. In the words of Professor Hannay, and I quote, "A company is an incorporated association which is an artificial person created by law, having a separate entity with a perpetual succession and a common seal." Unquote. This definition sums up the meaning as well as the features of a company succinctly. Features. The distinctive features of the company help to understand the realms of a company. The main features are: number 1, incorporated association. Registration of a company is mandatory under the Companies Act. The minimum number required for the same is 7 in case of public company, 2 in case of a private company, and 1 for one-person company. Number 2, separate legal entity. On incorporation, a company acquires a unique character of being a separate legal entity. It bears its own name and acts under the same and owns assets in its name. It has a separate existence from that of the subscribers to the memorandum and also from the personality of those who compose it. Members can enter into contract with the company, acquire rights against it, or incur liability to it. For the debts of the company, only its creditors can sue it and not its members. A company can own property, have bank account, raise loans, incur liabilities, and enter into contracts. A company is capable of owning, enjoying, and disposing of property in its own name. Although the capital and assets are contributed by the shareholders, the company becomes the owner of its capital and assets. The shareholders are not the private or joint owners of the company's property. A member does not even have an insurable interest in the property of the company. The leading case on this point is of Mekora versus Northern Assurance Company Limited in 1925. Mekora M. was the holder of nearly all except one shares of a timber company. He was also a major creditor of the company. M insured the company's timber in his own name. The timber was lost in a fire. M claimed insurance compensation. Held the insurance company was not liable to him as no shareholder has any right to any item of property owned by the company, for he has no legal or equitable interest in them. Number 3, perpetual succession. A company once incorporated can never be incapacitated till it is wound up on the grounds specified by the Act. Its members may come and go, but the company goes on forever. Even the death or insolvency or retirement of its members leaves the company unaffected. For example, companies like Tata and Birla are in existence for over 100 years. This is possible only due to the fact that the company has perpetual existence. Number 4, limited liability. Limited liability means that the member of the company, in case of liquidation or winding up of the company, cannot be called upon to contribute more than that has been agreed upon. The liability of a member depends upon the kind of company of which he is a member. Thus, in the case of a limited liability company, the liability of the members of the company is limited to the extent of the nominal value of shares held by them. In the case of a company limited by guarantee, the members are liable only to the extent of the amount guaranteed by them, and that too only when the company goes into liquidation. However, if it is an unlimited company, the liability of its members is unlimited as well. Number 5, artificial person. A company is an artificial person created by law and is clothed with all the rights of an individual and being subject to duties. It is called an artificial person since it is invisible, intangible, existing only in the contemplation of law. As a legal person, it can enter into contracts, possess properties in its own name, sue, and can be sued by others. However, it is not a citizen under the Citizenship Act 1955 or the Constitution of India. But certain fundamental rights enshrined in the Constitution for protection of person, for example, right to equality as per Article 14, are available to company, and also it has a nationality, domicile and residence. Number 6. Common seal. A company, being an artificial person, functions through its directors. Common seal is the official signature of a company, which is affixed by the officers and employees of the company on its every document. The Companies Amendment Act 2015 has made the common seal optional by omitting the words "and a common seal" from Section 9 so as to provide an alternative mode of authorization for companies who opt not to have a common seal. This amendment provides that the documents which need to be authenticated by a common seal will be required to be so done only if the company chooses to have a common seal. In case a company does not have a common seal, the authorization shall be made by two directors or by a director and the company secretary wherever the company has appointed a company secretary. Number 7. Transferability of shares. Section 44 of the Companies Act 2013 provides that the shares held by the members are movable property and can be transferred from one person to another in the manner provided by the Articles of Association. If the articles are silent on the provision for the transfer of shares, the regulations contained in Table F in Schedule 1 to the Companies Act 2013 are applicable. And if Table F is expressly excluded, the transfer of shares will be governed by the general law relating to transfer of movable property. However, in private company, there are restrictions with respect to transferability of shares, but the right to transfer is not taken away absolutely. The objective behind the right of restriction on the transfer of shares is to preserve the composition of the shareholding. Types of companies. The Companies Act 2013 has broadly classified the companies into various classes. Companies may be classified into various classes on certain bases. These bases are: Number 1. On the basis of liability. Company limited by shares. It is one in which the liability of the members is limited by its memorandum of association to the amount, if any, unpaid on the shares held by them as per Section 2, Clause 22. Company limited by guarantee. It is one where the liability of its members is limited by the memorandum to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of its being wound up as per Section 2, Clause 21. These types of companies may or may not have a share capital. Such a company may be useful only where no working funds are needed or where these funds can be held from other sources like endowment, fees, charges, donations, etc. In Narendra Kumar Agrawal versus Saroj Malu, the Supreme Court laid down that the right of a company limited by guarantee to refuse to accept the transfer by a member of his interest in the company is on a different footing than that of a company limited by shares. Similarly, the membership of a company limited by guarantee may carry privileges much different from those of ordinary shareholders. Unlimited company. It is a company where the liability of its members is unlimited as per Section 2, Clause 92, and the liability of a member ceases when he ceases to be a member. The liability of each member extends to the whole amount of the company's debts and liabilities, but he will be entitled to claim contribution from other members. Till the time a company is a going concern, The liability will be limited to the extent of shares. The creditors can institute proceedings for winding up of the company for their claims. The official liquidator may call the members for their contribution towards the liabilities and debts of the company, which can be unlimited. Number 2. On the basis of members. One-person company or OPC. The Companies Act 2013 introduced a new class of companies which can be incorporated by a single person. The concept of OPC was recommended in 2005 by a committee headed by Dr. J.J. Irani. Section 2, Clause 62 of the Companies Act 2013 defines one-person company or OPC as a company which has only one person as a member. OPC, unlike the sole proprietorship, is a separate legal entity with a limited liability of the member. Private company as per Section 2, Clause 68. Private company means a company having a minimum paid-up share capital as may be prescribed and which by its articles, number 1, restricts the right to transfer its shares, number 2, except in case of one-person company, limits the number of its members to 200, and number 3, prohibits any invitation to the public to subscribe for any securities of the company. Then comes small company. Small company given under the Section 2, Clause 85 of the Companies Act 2013 means a company other than a public company. This means paid-up share capital of which does not exceed 50 lakh rupees or such higher amount as may be prescribed, which shall not be more than 10 crore rupees. And secondly, turnover of which as per profit and loss account for the immediately preceding financial year does not exceed 2 crore rupees or such higher amount as may be prescribed, which shall not be more than 100 crore rupees. The features of small company are: number 1, a private company; number 2, paid-up capital not more than rupees 50 lakhs or turnover not more than rupees 2 crores; and lastly, it should not be a Section 8 company or a holding or a subsidiary company. Public company as per Section 2, Clause 71. Public company means a company which is not a private company and has a minimum paid-up share capital as may be prescribed. Status of private company which is subsidiary to public company. In view of Section 2, Clause 71 of the Companies Act 2013, a private company which is subsidiary of a public company shall be deemed to be a public company for the purpose of this Act, even where such subsidiary company continues to be a private company in its articles. According to Section 3, Clause 1a, a company may be formed for any lawful purpose by 7 or more persons, where the company to be formed is to be a public company. Number 3. On the basis of control. Holding and subsidiary companies. Holding and subsidiary companies are relative terms. A company is a holding company of another if the other is its subsidiary. According to Section 2, Clause 87, a company shall be deemed to be a subsidiary of another if the other company controls the composition of the board of directors or exercises or controls more than one half of the total share capital either at its own or together with one or more of its subsidiary companies. Associate companies as per Section 2, Clause 6. It means a company in which the other company has a significant influence, that is, control of at least 20% of total voting power or control of or participation in business decisions under an agreement, but which is not a subsidiary company of the company having such influence and includes a joint venture company. For example, A Limited is a public company and holds 23% of share capital in B Limited and 15% share capital of C Limited. By virtue of the shareholding pattern, B Limited will be known as the associate company of A Limited as the holding is more than 20%, whereas C Limited will not be an associate as the required 20% is not there and hence no significant influence. Number 4. On the basis of access to capital. Listed company. A company which has any of its securities listed on any recognized stock exchange is a listed company as per Section 2, Clause 52. Unlisted company means a company other than the listed company. Number 5. Other companies. They include government company as per Section 2, Clause 45. It is a company in which not less than 51% of the paid-up share capital is held by the central government or by any state government or governments, or partly by the central government and partly by one or more state governments, and the section includes a company which is a subsidiary company of such a government company. Foreign company as per Section 2, Clause 42. It is any company or body corporate incorporated outside India which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. Section 8. Company. Company which is formed to promote the charitable objects of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, etc. come under Section 8 company. Such company intends to apply its profit, if any, in promoting its objects and prohibiting the payment of any dividend to its members. Examples of Section 8 companies are FICCI, SHM, National Sports Club of India, CII, etc. These companies are licensed by central government and the registrar on application registers such person or association of persons as a company under the Section 8. On registration, the company enjoys same privileges and obligations as a limited company. The central government may revoke the license of such a company if it contravenes any of the requirements or the conditions to which a license is issued, or where the affairs of the company are conducted fraudulently or violate the objectives of the company or are prejudicial to public interest. But before such revocation, the central government must give it a written notice of its intention to revoke the license and opportunity to be heard in that matter. On revocation of the license in the public interest, the central government has power to amalgamate it with another company registered under this section having similar objects. Dormant company as per Section 455. Where a company is formed and registered under this Act for a future project or to hold an asset or intellectual property and has no significant accounting transaction, such a company or an inactive company may make an application to the registrar in such manner as may be prescribed for obtaining the status of a dormant company. Inactive company. It means a company which has not been carrying on any business or operation or has not made any significant accounting transaction during the last 2 financial years or has not filed financial statements and annual returns during the last 2 financial years. Nidhi companies. Also called the Mutual Benefit Society, it means a company which the central government may by notification in the official gazette declare to be a Nidhi or Mutual Benefit Society as the case may be. Its main objective is to lend and borrow money to the members for the purpose of their mutual benefits and to cultivate savings habits among the members. These are classified as non-banking financial companies or NBFCs, public financial institutions or PFI. By virtue of Section 2, Clause 72 of the Companies Act 2013, the institutions that are to be regarded as public financial institutions are: Number 1. The Life Insurance Corporation of India, established under the Life Insurance Corporation Act 1956. Number 2. the Infrastructure Development Finance Company Limited. Number 3. Specified company referred to in the Unit Trust of India, that is Transfer of Undertaking and Repeal Act 2002. Number 4. Institutions notified by the central government under Section 4A Clause 2 of the Companies Act 1956, so repealed under Section 465 of this Act. And number 5. Such other institution as may be notified by the central government in consultation with the Reserve Bank of India. An institution shall be so notified as PFI if it has been established or constituted by or under any central or state act other than this act or the previous company's law, or at least 51% of the paid-up share capital is held or controlled by the central government or by any state government, or partly by the central government and partly by one or more state governments. Formation and incorporation of companies. Section 3, Clause 1 states that a company may be formed for any lawful purpose by number 1. 7 or more persons where the company to be formed is to be a public company. Number 2. 2 or more persons where the company to be formed is to be a private company. Or number 3. 1 person where the company to be formed is to be one person company. A company formed under Section 3, Clause 1 may be either a company limited by shares, or a company limited by guarantee, or an unlimited company. Stages in the formation of a company. Formation of a company is a lengthy process involving completion of legal formalities and procedures. It involves number 1. Promotion, number 2. Registration or incorporation, and number 3. Commencement of business. Number 1. Promotion. The first stage in the formation of a company is promotion. At this stage, the idea to carry on the business is conceived by an individual or a group of persons called promoter. Thus, a person who conceives the idea of forming the company, floats the company, enters into preliminary contracts, agreements, and purchase of property in his own name, and hands it over to the company on its incorporation is called a promoter. A promoter may be an individual, firm, an association of persons, or a body corporate. However, a person acting merely in a professional capacity, for example, the solicitor, banker, accountant, etc., are not regarded as promoters. Every company shall inter alia, while preparing the annual returns, give particulars of its promoter. The Companies Act 2013 defines the term promoter under Section 2, Clause 69, which means a person who has been named as such in a prospectus or is identified by the company in the annual return, or who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, or in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. Number 2. Registration or incorporation. Section 7, Clause 1 of the Act provides for the detailed procedure for incorporation of company. Filing of the documents and information with the registrar of the company. The documents and information which is to be filed with the registrar, within whose jurisdiction the registered office of the company is proposed to be situated, are number 1. The memorandum and articles of the company duly signed by all the subscribers to the memorandum. Number 2. A declaration by person who is engaged in the formation of the company, like an advocate, a chartered accountant, cost accountant, or company secretary in practice, and by a person named in the articles, that is director, manager, or secretary of the company, that all the requirements of this Act and the rules made in respect of registration and matters precedent or incidental thereto have been complied with. Number 3. A declaration from each of the subscribers to the memorandum and from persons named as the first directors, if any, in the articles, stating that he is not convicted of any offense in connection with the promotion, formation, or management of any company, or he has not been found guilty of any fraud or misfeasance or of any breach of duty to any company under this Act or any previous company law during the last 5 years, and that all the documents filed with the registrar for registration of the company contain information that is correct and complete and true to the best of his knowledge and belief. Number 4. The address for correspondence till its registered office is established. Number 5. The particulars like names, including surnames or family names, residential address, nationality of every subscriber to the memorandum along with proof of identity, and in the case of a subscriber being a body corporate, such particulars as may be prescribed. Number 6. The particulars like names, including surnames or family names, the director identification number, residential address, nationality of the persons mentioned in the articles as the first director of the company. And number 7. The particulars of the interest of the persons mentioned in the articles as the first directors of the company in other firms or bodies corporate, along with their consent to act as directors of the company in such form and manner as may be prescribed. Particulars provided in this provision shall be of the individual subscriber and not of the professional engaged in the incorporation of the company, as per the Companies Incorporation Rules 2014. Issue of Certificate of Incorporation on Registration. Once satisfied, the registrar shall register all the documents and information in the register and issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated under this Act. The registrar shall allot to the company a corporate identity number on and from the date mentioned in certificate of incorporation, and it will be included in the certificate. And the last is commencement of business as per Section 10 Clause A. According to Section 10 Clause A, a company incorporated after the commencement of the Companies or Amendment Ordinance 2019 and having a share capital shall not commence any business or exercise any borrowing powers unless a declaration is filed by a director within 180 days of the date of incorporation in a prescribed form and verified with the registrar that every subscriber to the memorandum has paid the value of the shares agreed to be taken by him on the date of making of such declaration, and the company has filed with the registrar a verification of its registered office as provided in subsection 2 of section 12. In case of default in complying with the requirements of this section, the company shall be liable to a penalty of 50,000 rupees, and every officer who is in default shall be liable to a penalty of 1,000 rupees for each day during which such default continues, but not exceeding an amount of 1 lakh rupees. Further, the registrar has power to initiate action for the removal of the name of the company from the register of companies if declaration is not filed in 180 days and the registrar has reasonable cause to believe that the company is not carrying on any business or operations. From the date of incorporation, the subscribers to the memorandum and all other persons who subsequently become members of the company shall be a body corporate by the name contained in the memorandum, capable of exercising all the functions of an incorporated company under this Act and having perpetual succession until it is dissolved by liquidation or struck out of the register. A company on registration acquires a separate existence and the law recognizes it as a legal person separate and distinct from its members, thereby have power to acquire, hold and dispose of property, both movable and immovable, tangible and intangible, to contract and to sue and be sued by the said name. There will also come into existence a binding contract between the company and its members as evidenced by the memorandum and articles of association.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.